All right. Good afternoon. This is the House Judiciary Committee on Friday, the 15th of March, 2024. We have a number of bills we're going to be voting on this afternoon. And we're going to start a little out of order with House Bill 810, which is the Speaker's bill. It has to do with a switch or auto sear that is used and attached to handguns. There are amendments. There's a motion for a favorable on amendments and it's a second. Delegate Moon, I believe this amendment you're offering is 143723. Is that correct? Is that the right one? Do you need a moment just to make sure?
Yes, this is the correct one.
That's the correct one?
Yep.
All right. There is a motion on the amendment. Let's have discussion on the amendment. Delegate Moon, would you tell us what the amendment does?
Sure. The amendment achieves the same purpose as a bill, but with a different means. Around, I want to say 2018 or 19, when we were undertaking to ban bump stocks in the state, the advocates asked us not to write it specifically as to bump stocks, but instead to write a catch-all crime that captures bump stocks as well as any other devices that circumvent the ordinary firearms control to accelerate the rate of fire. So that existing definition is on page 4 of the reprint. Rapid fire trigger activator means any device, so on and so forth. And it gives a list of examples on line 6 of page 4, bump stock, trigger crank, hellfire trigger, binary trigger system, burst trigger system, switch auto sear. And it inserts auto sear into that list of examples. The bill as introduced would have created a separate crime for this one device or manufacturer. So that's the amendment in a nutshell. And I do see one error actually in the amendment, if I can just orally amend a single word. On page 4, line 6, where it says rapid fire trigger activator includes a bump stock. It shouldn't actually delete it on trigger crank. Trigger crank is a term of art. But otherwise, Baltimore County had requested that if we went in this direction, we alter the catch-all phrase from rapid fire trigger activator to just rapid fire activator, so as to catch potentially a more clearer set of these devices. And the definition that's applied here on lines 15 on page 4 come from a Department of Justice definition from a case they tried.
Okay. That's the description of the amendment. Are there questions for Delegate Moon or for me about the amendment? Delegate Card.
Thank you. I appreciate Delegate Moon always trying to make things more efficient and work the code properly. And I think that the intent is great. I'm not going to support the amendment. I'm presuming the amendment's going to pass because our county and our prosecutors said that with the federal definition as it stood in the original bill, they know they'll be able to prosecute. And there's always a question as to how it will be implemented in the future. That being said, I think that we're going to be good either way, but just want to, on behalf of my county executive, I'm going to do what I'm going to do.
I appreciate the concern. And what I will say is before this bill even existed, I had read about auto sears being found in Montgomery County, and I had my office actually call the state's attorneys to see if they were charging the auto sear and MoCo under the rapid fire trigger activator law, and they were in fact doing so already. And so I do believe shunting the auto sear into the list of examples is the proper way to do this. Maryland already, again, in 2018, diverged from the feds in how we approached our ban.
Are there other questions? On the amendment, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. The chair votes 11. All those opposed? Need a simple majority for this. 1, 2, 3, 4, 5. And so the amendment is adopted. It's a motion for a favorable as amended. And a second. 1, 2, 3, 4, 5, 6, 7, 8. I'm going to hold this to the end of the calendar. There are some people who aren't in the room. We want to make sure people have the opportunity to vote. So I'll hold this until the end of the voting session today. Go now to House Bill 37. Again, there are amendments on this legislation, and Delegate Bartlett, in her quest to lower the fiscal note, has done many things. And so Delegate Bartlett, would you please, could I have a motion on her amendments? Moved and seconded. We'll go to discussion on her amendments. Delegate Bartlett, please, the vice chair, for tell us what's in the amendments.
Sure. So we have amended the title to pertain to the intent of the bill, and that is services for formerly incarcerated women. We have a commission and a pilot program that was already in place, but now we have GOCAP essentially running the pilot program for us, and they will issue grants, hence the lowering of the fees, because the only lowering of the fiscal note, because that is what GOCAP does. They already have a grant program in place, so we don't have to get an agency that doesn't do the work. And I've talked to, well, the other thing is that we're going to have county level agencies working with these formerly incarcerated women. We're going to have a reentry professional who has direct experience providing services to women over the preceding 7 years, as well as a co-chair will be a formerly incarcerated woman. There are other members of local agencies who will be a part of the commission. The pilot program will identify existing programs available to currently and formerly incarcerated women through state agencies, and it'll be all overseen by GOCAP, as I mentioned. The pilot program will partner with local organizations, and literally I got this sentence because this is what GOCAP, Department of Labor, and DPS asked for, and that is to ensure that everyone works in partnership. So that's the amendment.
We did that and we seconded it, and then he left.
I'm sorry, there's one other thing.
There's more.
There's one other thing. We did strike this as a they had a sunset. We struck the sunset because we were able to get the funds, and it's a good program and everybody likes it.
All right. Are there further questions about the amendments? Delegate Valentine.
So does this eliminate the fiscal note altogether?
It does not eliminate altogether, but I have reduced the fiscal note significantly based on the wonderful work that GOCAP already does. So they have stated that they're going to need to hire 2 individuals. So it lowers the fiscal note from where were we originally? It lowers the fiscal note to, we were at 500,000. So we've lowered it to below 150,000. So it's below 130,000, actually, 128.
And those two positions, are they contractual
They're
positions?
contractual
Okay.
positions. Yeah. Thanks for the question.
Further questions? Delegate Schmidt?
Thank you, Chair. So because it doesn't, you remove the sunset in the amendment, is it still the pilot program? Is it?
It'll be a pilot program for 3 local agencies. And those lake agencies can continue. We would have to create a new bill to go ahead and go with if we wanted to bring in more. And that would do it. Because it's a 5-year plan that the commission comes up with. And they'll have the pilot program, but this way, if for some reason the pilot program takes a little time, getting getting on track, then we'll have that time.
Okay.
Yeah, that's why I didn't want to sunset it. Thank
All
you.
right. Thank you. Makes sense.
Further discussion on the amendment? All right. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? The amendment's adopted. We're on the bill as amended. Is there a motion? It's a motion for a favorable and a second. Here we are. Discussion on the bill as amended. Seeing none. The vice chair? Yes. Crutchfield? Yes. Cardin? Yes. Embry? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Is excused. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes, and can I get a me too?
Yes. Williams with an add-on. Okay. Crutchfield? Embry? I think that's Shorty. Tolles? Phillips? Taylor? Simpson? Conaway, and Kaufman. All right. Going to beg the indulgence of the committee. If you want to add on going forward here, we got a little bit of work to do. Please do it as we go along. So we will continue to move as quickly as we can. I'm gonna hold on to House Bill 87 just for a moment. We'll go now to House Bill 105. 105 has an amendment that I'm offering, and it's a motion for a favorable on the amendment. Is there a second to the amendment? Thank you. You'll see the interlineated copy of the bill at 343921. We've had versions of this bill for many years, and it would require that people who receive a probation before judgment for a drunk driving offense have the interlock installed in their vehicle as part of the sentence that they receive for their probation before judgment. One of the concerns the committee has had over time has been whether or not a PBJ alone, being that it didn't act as a conviction, was enough to justify the expense for people to have to put the interlock onto the car. However, I think that we found a middle ground that might just work. We'll find out in the next 3 weeks. And what the amendment does is it makes a change to the bill as it was initially drafted. That first, so I got to walk through what happens when you are alleged to be driving under the influence. So when you're alleged to be driving under the influence, you go through a process where you're given a choice, basically, in most situations, whether you want to be suspended or whether you want to take the interlock. What the amendment would say is the day that you decide to take the interlock, that starts the 180 days. So that would start the 180 days that you would have to that you would have to complete the interlock. So it does that, and then further, it has a data requirement that asks the MVA to collect data as to the people who are required to participate and how many of them were granted a probation before judgment, and then how many people were charged or convicted of a further violation. And they would have to start reporting that information in 2028. So in other words, 3 years down or 4 years down the road, they're going to be able to take a look back and say, okay, here are the people who are on the interlock. Here are the people who received PBJs. How many of them came back and committed another drunk driving offense? Because one of the questions that continues to come up, and there's just this general, we're not quite sure, but we have sort of federal numbers. We should be able to track that. And I think that we'd be able to do that through the data requirement here. So this amendment was moved and seconded, and I'm happy to take any questions that people have regarding it. Delegate Roberson.
Yeah, thank you, Mr. Chair. And just for my clarification. So what you're saying is before you go to court, you receive a PBJ.
So the process from beginning to end, the process from beginning to end is you're arrested. You're taken to the barracks, usually either state police barracks or a county police, where you're read basically they read from a form, a DR-15 advice of rights, goes through all of your options. You can then choose to take a breath test or not take a breath test. If you refuse the breath test, we have on the law that already that you basically are going to be deciding whether or not you want to be suspended or go on the interlock from right then. If you decide to take the test and you blow over, I think it's a 0.15, then you're automatically put on the interlock right then. So generally speaking, in either case, you have to decide what you want to do. The person then would decide whether or not they wanted to be suspended or be placed on the interlock. That happens. They then have their trial. The trial happens. The judge decides whether or not to give them a probation before judgment or not. What this bill was seeking to address is that in almost every other situation, if a probation before judgment acts not as a conviction, but it acts just solely as probation. So it's not meant to count as a conviction on your traffic record or your criminal record. So some people will go through the whole process and they'll get a conviction at the end. We're not talking about those people.
Right.
The people we're talking about, generally speaking, this is their first time and the court says, we're going to give you probation before judgment, probation before we put a conviction on your record. And this bill would say, but we still want to make sure that you've done the interlock for at least 180 days.
Got it. So initially what was proposed is you receive a PBJ, you would, I'm sorry.
You would
bill
have to do the
proposed that you would do
180 days from the day of the PBJ.
Got it.
What the amendment says is you're going to have to do the 180 days from the day that you first have to put the interlock on your car, because it's possible that you had to put the interlock on your car prior to the time that you actually go through and are sentenced for the crime one way or the other.
Got it. And also the other change is that
Data requirement.
Is the option, what you're proposing is you choose either suspension or interlock.
That's existing law. That is already existing.
That's
law.
already
So
there.
nothing changes with that. People once they're pulled over have that choice one way or the other.
Got it. Thank you.
And if members of the committee would like to see a more in-depth statement, I'm not going to put our trooper on the spot, but I'm sure he's read a couple DR-15s in his life. We will not do that to him. But you can Google DR-15 and it will pop up on the state police's website. And there are many people raising their hands. I'll start with Tomlinson and make my way around.
So, when you're saying, so back up here. So when you get a DUI, you first, before you ever go to district court, you'll go to the you'll have your administrative hearing. That's usually how that works.
Yes.
So you're saying that you go to them, and so usually you go to the administrative hearing, and that's when it's decided whether you're gonna lose your license, or are you saying in this case that is when you'll get that's when you would be able to start the interlock? Or are you saying even prior to
Effectively, yes, effectively. I think I'm actually getting that part of it right. But that's part of the process from beginning to end with the that's laid out in the advice of rights that people receive once they are arrested for driving under the influence.
Yeah, because I mean, in the past, if I'm just, okay, just will make it.
I will grant that I've simplified it a little bit because yes, there is the administrative hearing with MVA. There's also the criminal hearing that's going on at the same time. The interlock kicks on at the administrative hearing, which happens prior to the other. But you're making a choice at that point whether you're choosing to have your license suspended or go on the interlock.
Yeah, because I mean, if you go to the let's say you go in June, you have your administrative hearing in June. You were to get your license suspended for 3 months, and then your actual district court hearing isn't until August. You would get your license. You would have your license back a month after your district court hearing because the 3 months started 2 months prior to going to district court. So you're saying this is basically the same idea, except it's just with the interlock?
If they're choosing to get their license suspended, I think their license would be suspended for either 180 or 270 days. So it's unlikely that they would, unless there is some administrative ruling that decides to go a different way, which is not supposed to happen, but at least in my reading of the law, that's not supposed to happen. All I'm saying is at that front end, they have to make that choice. They're making a decision whether or not to have their license suspended or agree to take the interlock. And so for those people who take the interlock, that would start the 180 days that they would be required to, for a first time, that they would be required to have the interlock on their car under this amendment and under the bill.
Do you still have the option
you do. You would
to
have,
sit at home for 100 to not have a license for 180 days?
You have the option to stay at home, but then where the law would kick in is that then once you did go to district court, the court would then require you to do the full 180 days. So
as a result of it.
As a result of this bill.
Yes.
So one way or the other, you're doing 180 days with the interlock. You're either going to choose to do it at the front end or you're going to choose to do it upon conviction.
That's what I thought.
Upon the probation before judgment, yes.
That's what I thought. Okay.
If they get a probation before judgment. Delegate Eric Hand, I'm coming right around.
I just want to confirm that the sponsor's okay with the amendment.
I've talked to the sponsor about the amendment. I feel like we've gotten it to a place that
Close enough.
people can
Okay.
live with it. It's going to be in a different posture from the Senate. So we'll figure this out and hopefully we'll get this over with.
Okay.
Delegate Valentine.
I believe you just answered my question
Yeah.
when you answered Delegate Tomlinson. I just was concerned if you have the interlock, you do your 180 days, for whatever reason, you have postponements, et cetera, it's into the next year. The 180, it's JTP, whatever it goes to jury trial. Your 180 days are satisfied with the interlock. When you're given the PBJ, you don't have to start over. You've already satisfied the requirement, or could you in essence possibly have to do another 180 days?
No, you would have satified the
Satisfied
180
the
day
day
requirement because that's the way it's crafted in the bill. Yes. So
Okay.
you'd be done the 180 days one way or the other. Just as an aside, I mean, if it's charged under the 60-day offense, they don't have a jury trial right. So I think the number of times where it would go that long, like a year, would be not incredibly often, but I guess not impossible. It just depends on how it's charged. Yeah, and the judge can require it anyway. Is the other part of this is the judge could require an interlock if they think that there's some extenuating factor anyway. Delegate Conway. That's this part of the law. Yeah. Okay. Not make a light of it. This is
Right, so we're moving.
We're adding another thing to this part of the law.
Right, we're
Yes.
moving from after you go to court, you could be required to do the 180 days to you could elect to do the 180 days before you go to court. And then if you go to court and are found guilty, you might be required to do another 180 days?
No, the bill says and doesn't change that for a first offense that you would be required to do 180 days on the interlock program.
Irregardless.
Right, regardless of whether you finished the 180 days or not.
The 180-day suspension.
180 days on the interlock is what's required under the law.
If you decide to take the suspension,
I believe it's, I'd have to go and
That-
pull up
that-
my DR-15, but I left my computer in my office.
all right, thank you. Mr. Chairman.
But yeah, it's either 180 or 270. I can't remember exactly what it is at the moment. Delegate Cardin. No, you didn't have your light on. All right, Delegate Phillips, I'm going down there.
Yep. So I have a question with regard to ability to pay, and I think somebody, at one point that was answered. Because if I go on the interlock, then I've got to pay for the interlock, right?
Yes.
And if I have a PBJ, then when do you've got to start paying for it when you make that decision?
Yes, you've got.
Is there a provision for those who may be somewhat indigent?
Yes, there's a provision for those people who are indigent. And I would say that another thing that I'm currently working on is trying to get perhaps a study done. I'm going to ask MVA for information for the number of times that indigent people have to participate in the interlock program, how many people they are there in a year. And I think I want to ask them that California has, and this is beyond the scope, I think, of this. This is where it starts to get a little more complicated. California and a couple other states have a fund that people pay into that the intoxicator companies pay into that creates money to provide for support for indigent people. And I think MVA should look at that and see if there's a way that we can extend out services. But in order to know what we're doing, how many people that would be, I want more information from them on that universe, and then the universe of people who maybe don't qualify now, but sit right over that line.
Okay.
So I think we need more. So that may be coming attractions. That may be another bill. Okay, it was moved and seconded. All in favor of the amendment, raise your hand, please. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? The amendment is adopted. We're on the bill as amended. There's a motion for a favorable and a second. Discussion, Delegate Cardin.
I have, I've requested an amendment. It is in drafting. I thought it was going to be here in time. It's not. The amendment is to, if it's for anybody with a first time PBJ, and they successfully complete it with the interlock and everything, that after 10 years, it's expungible. This is an amendment that we considered last year. I'll do an oral one. It's in waiting, and
There's another bill that's up in the air still at this point. So if it's not drafted.
I mean, it's in,
wanna move forward with this.
they said they're working on it as quickly as they can. I'm trying.
I understand. I think there's another bill that's actually drafted that's on point, and I believe that the Senate's already passed it, so it's going to be coming here anyway. So we'll address that issue, I think, with that bill that comes across the street. All right. Any further discussion? Delegate Tomlinson.
So to Delegate Cardin's point, or his amendment, and you brought up the Senate version, so it's the Senate version of this bill has been amended like that, or you're saying it's a separate bill? So
No, there's a separate bill that deals with expungement of the DUI. And I will say that when we passed the bill at the last day of session last year, it included the expungement provisions. There were people who weren't happy that the expungement provisions were in the same place as the interlock provisions of the bill. So knowing that the Senate is moving that bill over here, that we can deal with that issue when the Senate brings that bill over here and leave this bill alone.
okay, so the idea is not to
Not
Okay.
to mix the two at this point, no.
As, okay, not do
Yes.
what happened on Sunny
Yeah.
Diet.
Yes.
And then the second question.
No thanks.
Second question was, I'm sorry, I meant to ask this with the amendment. The, if you are end up, if you're found not guilty, if you're found not guilty in district court and you are, I mean, I guess if you already did the 180 days interlock, it's, well,
Then you're done.
you're done. If you're found not guilty and you're in the middle of those 180 days,
Then your lawyer would file something with the on the administrative side as to the interlock, and you're having to be on the interlock anymore because it's not. Because you would no longer be required to be on the interlock anymore and it would get removed from the car.
okay,
right.
thanks.
Seeing no other questions. The Vice Chair,
Yes.
Crutchfield, yes. Carden, yes. Embry, yes. Pasteur, yes. Tolles. For the bill is amended, yes. Schmidt, yes. Simmons, as excused. Boucher, yes. Phillips, yes. Roberson, yes. Tomlinson, no. Erican, yes. Taylor, yes. Simpson, yes. Grammer, yes. Moon, yes. Valentine, no. Conaway, yes. Kaufman, yes. Williams, yes. All right. Send that to the floor. Okay, 128 went to subcommittee. Whose subcommittee did it go to? Went to David Moon's. There are no amendments apparently. Oh, there are amendments apparently. Delegate Moon, would you tell us what the amendments do?
So the bill came in trying to clone the prohibition on threatening a witness in a judicial context, and bringing that type of crime over to the legislative context, and to make a separate crime out of threatening harm on a witness to a legislative proceeding. It offered a 10-year penalty for that, and the subcommittee, albeit on a close vote, narrowed the bill to just threats of physical harm, and then dropped the penalty down to 3 years. And it moved, I think, unanimously with that amendment, though I will concede for the purposes of the record that the bill sponsor had intended to aim the bill at non-physical harms. But again, the subcommittee at the moment was comfortable moving the bill with physical harms.
Second.
Motion and a second on the amendment. Is there further discussion on the amendment? Seeing none, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Anybody opposed? Seeing none, the amendment's adopted on the bill. Motion for a favorable and a second. Any further discussion? Any further discussion? Seeing none. The Vice Chair? Delegate Crutchfield? Yes. Carden? Yes, okay, yeah, sure. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right. $145. Did this also go to the subcommittee? I think it did. And there's an amendment. So Delegate Moon or? Yeah, amendment is 233726.
Thank you, Mr. Chair. So this one also came out of sub with changes. The bill as introduced was attempting to add deep fake and simulated, realistic looking simulated pornography where you've used someone's actual likeness and made this deep fake pornography. It's attempting to add that to revenge porn where you have in your possession someone else's intimate photos that they have an expectation of privacy for, and you've released those to the world. That revenge porn crime comes with 2 years. And the subcommittee moved deep fakes and simulated pornography into the harassment section of code. And that comes with a penalty in I think 60 to 180 days for first or second offense. And we further extended the statute of limitations on charging a deep fake porn for up to 5 years. So that was where we landed on that. The idea being that it's a very bad, worse offense to actually put into the world someone's actual photos and videos of them that you have versus you using a computer program to make something fake with someone's head. So that's where we landed.
The motion for a favorable and second amendments discussion to Delegate Erican.
Also, just to clarify, it's 5 years after the victim discovers them, not 5 years from when the event occurred.
Anybody else? Seeing no further discussion, the Vice Chair?
Yes.
Yes. Crutchfield? Yes. Cardin? Oh, I'm sorry. We didn't do that part, didn't we? Let's move the amendments. All in favor of the amendments, raise your hands. Oh, boy. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. I do apologize. Anybody opposed? 1, 2, 17 to 2. I'm sorry. I do apologize. All right, 16 to 3. On the amendment, but the amendment's adopted anyway. And we're going to go now on the bill as amended and seconded, and it's for a favorable now discussion. Sorry about that. Delegate Conway.
Thank you, Mr. Chairman. So there's no time limit on when the action can be taken on this bill?
5 years. So 5 years from discovery of the.
So if you don't discover it for 10 years, is the statute of limitations run out?
It's +5.
So therefore it could be 10 years later.
It could be.
And so this could happen 15 years later.
It
You
could
knew
be.
what I was asking.
Yep.
Thank you very much.
Any more? Any more discussion? All right, let's try this again. The Vice Chair.
Yes.
Yes. Crutchfield. Yes. Cardin. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. No. Kaufman.
Yes.
Yes. Williams. Yes. House Bill 195. There are amendments. So many amendments. The subcommittee chair, please. Delegate Williams.
It's that were offered by, oh, shucks.
Turn on your mic, please.
Yeah, the
Thank
mic
you.
might be helpful. Thank you. Yes, there are amendments to this bill to alleviate kind of some of the concerns that were raised by some of the disability groups. The purpose of this bill is to help missing persons with impairments, cognitive impairments, whether regardless of age, And so that's how it differs from, say, a silver alert or some of the other alerts that we are familiar with and accustomed to. The amendments just simply, I'm gonna go back to. Oh, that would be helpful. Thank you. Expands the scope of the program to include individuals who have mental disorders and individuals who are deaf, and authorizes the Department of State Police to consult with relevant stakeholders in developing the details of the program.
Move the amendment.
Motion for the amendments, second, discussion on the amendments, please. Don't see anybody discussing.
Yeah, the sponsor's fine with it. Yeah, she was the one who put forth these amendments.
All right. Appears that's the case. All right. Any further comments on the amendments? Seeing none, all in favor of the amendments, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Anybody opposed? Seeing none. All right. We're on the bill as amended. Motion for a favorable in a second. Is there further discussion on the bill as amended? Seeing none. The vice chair?
Yeah.
Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
I'm letting Erican add on, but all right, from now on, I'm being mean, and you got to do it when we vote because I can be mean. How dare you? House Bill 222. This is. Now I'm upset. Oh, House Bill. You're all so insincere. This is terrible. House Bill. Do we have an amendment on this bill? There are 2 Yodas now. I don't know what to do. Who do I ask? All right, so I don't believe there's an amendment on the administration bill that is 222. Favorable. All right. Claire, do you mind giving us just a brief description? I believe this is just it's just adding locations, I believe, to existing, well, it's doing a couple other things too. Can you give an overview, please?
Yes. The bill just deletes obsolete, or it updates obsolete references to facilities and positions within the Division of Pretrial Detention and Services. And it specifically, it repeals references to the Baltimore City Detention Center and its warden, and adds references to the Youth Detention Center and its facility administrators, the Centralized Booking Facility, the Maryland Transition Center, and the Chesapeake Detention Center.
All right, questions on the bill? Seeing nothing, there's a motion for a favorable and a second. Any further discussion? Seeing none, the vice chair.
Yes.
Crutchfield. Carden. Embry. Pasteur. Tolles. Schmidt. Simmons. I gotta get that. Boucher. Phillips is stepped out. Roberson, Tomlinson, Erican, Taylor, Simpson, Grammer, Moon, Valentine, Conaway, Kaufman, Williams.
Yeah.
All right, that was unanimous. All right, House Bill 288, Delegate Pippy. There are no amendments to this. This went to a subcommittee, or no? I didn't send this one to a subcommittee. No. It did pass last year. I remember we had this last year, so I'm gonna send it back one more time. Then the Senate can figure out what to do with it. All right. Right. Discussion on the bill, no amendments. A motion for favorable in a second. Any discussion? Seeing none. The vice chair.
Yes.
Yes. Crutchfield. Yes. Cardin. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Still not back. Yes. No. Yes. Wait. Phillips on 288. Delegate Pippy's bill on visual. Yes. Okay. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Sorry. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Oh, now Williams is out. It's that time of year. 222, Delegate Phillips would like to be a yes on that bill, and everybody else was a yes on that bill. Any objection? Are you really objecting? All right.
I'm here.
All right, so we're a yes on Phillips for 222, and for 288, Williams is a yes. We hadn't quite finished that one. We moved, that one is complete. I can scratch that off and I can go to the next page. Very exciting. Delegate Woods has a bill in our committee. I don't know. It's foolish, quite foolish to bring a bill in this committee, I suppose. But having said that, everyone thinks so.
There's some amendments though.
There are, because it went to the subcommittee. Yes, we'll move the amendments. Is there a second? There is. You want to talk about the amendments? Was it
Well,
yours?
Claire's gonna talk about the amendments. I don't have any notes. I think if they're great amendments, I know. Let me turn my mic on.
They're highly regarded amendments that Claire is going to talk about.
Yeah, they are highly regarded amendments. So the amendments do address the concerns that were raised by the chiefs and sheriffs. And it also raised the concerns that were brought up by Prince George's County Police Department. We had this bill in our subcommittee, and they all stated that they were all in favor of the amendments that were proposed by Delegate Woods. The delegate herself is also okay with all of the amendments. And so that's where we are, Mr. Chair.
Anyone have any questions? Delegate Erica.
Oh, yeah, thank you. So I just wanted to, maybe not, this is not on the amendment though, so maybe I'll just wait till the bill. Yeah.
Any questions on the amendments?
It's not in, it wasn't in my packet.
833520, no? Okay.
Want me to Yeah.
Why
about
don't
in
you
more
walk
detail?
through? Yes, please.
So the amendments just basically tighten up this procedure. They add a definition of interested party, alter the definition of qualified request, require that a wellness check be conducted without unreasonable delay instead of immediately, and apply the wellness check requirement to fire, rescue, and emergency medical services entities as well as law enforcement agencies. So basically, the bill requires a law enforcement agency or a fire, rescue, and emergency medical services entity that receives a quote unquote qualified request from a quote unquote interested party for a wellness check of an individual to, without unreasonable delay, conduct a wellness check of the individual if the individual is located in the agency's jurisdiction, or submit a request to the relevant law enforcement agency or fire, rescue, and emergency medical services entity in the state or another state to conduct a wellness check if the individual is not located in the agency's jurisdiction. And a law enforcement agency or a medical services entity that receives a qualified request must meet these requirements regardless of where the individual or entity making the qualified request is located.
the vice chair, then Valentine.
Thank you. Claire, did you say who's defined as person in interest?
Qualified, let's see, person in interest. Interested party
Interested party, that's what.
means a healthcare practitioner as defined in the health general article, or another interested person who has sufficient information to inform the authorities of another individual's health-related condition or circumstance that represents a life-threatening emergency.
Thank you.
Valentine?
Mr. Chair, I just want to clarify, is the reason we have the same wording twice because police are under the public safety article and health general covers the fire and EMS?
Well, they're both in the public safety article, but they're just two different titles
Mhm.
in the public safety article.
Okay, thank you.
Okay. Further questions about the amendment? All right, seeing none, all in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Anybody opposed? Opposed? Seeing none. All right, we're on the bill as amended. Motion for favorable in a second. House Bill. I think they eliminate, it effectively eliminates the fiscal note, I think is what. There, I don't think there was a fiscal note here, right? Yeah, no.
Yeah.
Okay. Delegate Erica.
Thanks. So, there's just a little piece of this. I mean, I love the concept and I remember the testimony was very moving, but I just want to make sure, does this bill actually do, what it's supposed to do? And, are there any potential repercussions? Like, so we make the call, it's a qualified person. They obviously don't need a warrant to enter the premises at this point. So it's sort of like warrantless entry. And then let's say that, I don't know, there was false pretenses or there was never a medical emergency situation. Like, are we getting into a weird area where we're sort of violating somebody's rights? How does that play out in practice?
I don't think, yeah, if it's a wellness check, I don't think that they're busting down the door.
Well, that was the
because-
problem, right, with the case that she had. No one went into her son's home to see if he was okay, and he was not.
Delegate Williams.
Well, yes, that is correct. With her son's case. The apartment building wouldn't open the apartment without either the police with them or something along those lines. Because it was out of state, they needed Prince George's County Police to communicate to their police department before they were willing to move. Because as a Prince George's County resident, the wellness check technically, at first she called down to Virginia, and Virginia was like, we can't speak to you. You need to call your local police department so they can tell us to do it. And that's where the hiccup came.
Okay.
And so it wasn't necessarily getting access. It was more just the communication to between the various police departments.
Okay, so in that situation, we've got an apartment building. They actually have a right to enter properties already in the contract. So how would this apply in a private property situation? So somebody does a wellness check on me, I'm not answering the door. Can the police then enter my residence without my consent?
Unless there's some type of exigent circumstances, they wouldn't be able to enter your property.
And the wellness check is not an exigent circumstance per
And
our code currently?
Not necessarily. Not necessarily, depends on the circumstance.
Bit of a gray area. Okay, all right. I was wondering, I still like the bill. It's a little bit of an oddity.
All right, seeing none, and we adopted the amendments, I believe. And we've got a motion for a favorable. And a second, Vice Chair?
Yes.
Yes, Crutchfield?
Yes.
Yeah, yes, and an add-on. Carden, see how that works? It's just very easy. Carden, yes, and an add for Carden. Embry? Yes. Pasteur? Yes, and an add. Toll? Yes, and a make sure I'm still on the bill. Tolls? Yes, and an add for Tolls. Schmidt? Yes, and an add for Schmidt. Boucher. Yes. Phillips. Yes, and a make sure for, and an ad for Phillips. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes, and an ad. Kaufman?
Very briefly explain my vote, Mr. Chair.
Yes.
My dear friend Jamila, this is for you.
Oh.
Yeah.
All right. Williams?
Yes.
Yes. It's adopted. Motion's adopted. Now Delegate Phillips, House Bill 458. There are amendments because this went to family? No, it didn't. They're just amendments. Delegate Phillips, would you tell us please what the amendments do?
Part of it is to conform with the bill that passed out of the Senate. So it was clarifying language in the purpose statement. Then there was an exception to the rule where the court, by clear and convincing evidence, that there is good cause to include the minor's name. It adds some definitions and so that the court will know when they have a minor engaged in the court proceeding. And that is it.
Favorable on the amendments and a second. Further discussion on the amendments. Don't see any further discussion on the amendments. All in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Anybody opposed? Seeing none. All right, the amendments are adopted. Motion on the bill. This motion for a favorable and second discussion. So now can you give us the full picture of exactly what the bill does with the amendments, just so we make sure we got it?
So the first piece was changing the purpose statement. So a court or a party in a criminal or juvenile delinquency case may not disclose or allow inspection of a certain court filing, et cetera. That first one eliminates the language authorizing the Supreme Court of Maryland to adopt rules and requiring or authorizing a person making a redacted filing to also file an unredacted copy under seal. So it removes that. Provides for an exception to this rule where the court, by clear and convincing evidence, determines that there is good cause to order otherwise. It adds this idea that you must provide identifying information up front so that you know that there is a minor who is participating in this court proceeding. The court asked for that. Judiciary asked for that, so they would be on board. And those are the changes.
Okay. All right. Just questions, further discussion? Novels you're working on? All right, hearing none. The vice chair. Crutchfield? Carden? Embry? Pasteur? Tolles? I can't hear you. Okay. Ooh. Schmitz. Boucher. Yes. Are you sure? You know, you sit next to him and everything. Are you really sure? Phillips, you want to vote for your bill? Yes. Okay. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yeah. Yes, and an ad. Kaufman? Yes, and an ad. Williams?
Yes, and an ad.
Yes, and an ad. I'm not doing anybody else because I'm such a meanie. All right, now we're going to 496. This went to David. This is to Delegate Moon's subcommittee, please. Are there amendments? There are. Would you please talk about the amendments and then we'll do a motion.
There were two, so this, thank you, Mr. Chair. This was the bill to repeal a force requirement on a second degree sex offense. The sponsor brought in two amendments that we adopted. They're both narrowing amendments. And one of the amendments suggests that the perpetrator knows or reasonably should know that the victim would submit as a result of fear, threat, or coercion. And the other amendment further clarifies that the analysis shall be determined based on a totality of the circumstances, including the words and conduct of the victim and the defendant. And so I would move those amendments.
Please. Anyone? Okay, all in favor of the amendments, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Anybody opposed to the amendments? All right, the amendments are adopted. Motion for favorable and a second on the bill. Discussion on the bill as amended. Okay, the vice chair. Yes. Crutchfield. Yes. Cardin. Yeah.
Hope we're not down this road where we are going to be dealing with young people who make mistakes, but I hope that we've solved the problem with the bill as amended. So.
Delegate as Cardin, yes. Embry, yes. Pasteur, yes. Tolles, yes. Schmidt, yes. Simmons is not here. Boucher, yes. Phillips, yes. Roberson, yes. Tomlinson, yes. Erican, yes. Taylor, yes. Simpson, yes. Grammer, yes. Moon, yes. Valentine, yes. Conaway, no. Kaufman,
Yes.
yes. Williams,
Yes.
yes. It is favorable, is adopted. Let's go on to 508. Embry's bill. There are amendments and this, you get this? Yes. Delegate Crutchfield, would you like to tell us what the amendments do, please?
Yes, actually, the amendment just really defines labor trafficking. And the bill actually is adding child labor trafficking as defined into a section of the law under the Safe Harbor Regional Navigator Grant Program to allow for services for victims of child labor trafficking.
We have a motion on the amendments. Moved and seconded on the amendments. Further discussion on the amendments. Anyone? Bueller? All right, seeing none, all in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Anybody opposed? Seeing none, the amendments are adopted. We're on the bill. The bill is amended and seconded. Any further discussion on the bill? All right. The vice chair.
Yes.
Yes. Crutchfield.
Yes.
Yes, and an ad. Cardin. Yeah. Embry. Yes. Would you like to add? Pasteur. Yes, and an ad. Tolles. Yes, and an ad. Schmidt. Yes. Simmons, still not here. Boucher. Yes. Phillips. Yes, and ad. Roberson. Yes. Tomlinson. Yes. Erican. Yes, and an ad. Taylor? Yes and an add. Simpson? Yes and an add. Grammer? Yes and an add. Moon? Yes. Valentine? Yes. Conaway? Yes and an add. Kaufman? Yes and an add. Williams? Yes and an add. I made marks all the way down the line, and so poor Claire, or no, this is not me. Yeah, all right, sorry. Okay, Delegate Atterbury. There are amendments. Are there amendments? So this conforms with the Senate. This is 683822. Second. So it sets the statute of limitation for prosecution for sexual extortion to 5 years. Statute of limitations for the prosecution of stalking would go to 10 years. All right. With the amendment. That's the amendment. And what is revenge porn again? No statute of limitations with revenge porn. Let me get the can I have a motion on the amendment? Moved and seconded on the amendment. Delegate Conaway.
And so if you could prove someone stalked you 9 years ago, then you could bring them up on this charge?
Do you want to, Vice Chair, do you want to?
No. I have to do my research. I'm sorry.
So.
Me just said 10 years, right?
Right.
So that's why I use 9 years.
Right.
So I'm saying 10 years or less.
Going
So
to
it's
bill.
at 9 years, you could bring someone up on a charge in 2003 or something. Somebody stalked you.
Okay, so Madam Vice Chair.
I'm ready now. Yes. And because there are circumstances sometimes where the statute of limitations is necessary for these types of crimes, because it does take some time to get over the emotional hurdles that one has to get over.
9 years.
It could
Okay.
happen.
Oh, yeah. Only known you for 4 years. So.
Carden, Delegate Carden.
Thank you. Right now, the statute of limitations for revenge porn is what, Claire? Is there a statute of limitations?
If it's a misdemeanor.
Yeah.
Which it is.
And sextortion, what's the definition of sextortion? It's also 1 year.
Sexual extortion. 370.
Bill.
So
Just read this a minute ago.
I'm going to ask the question while we're looking at that, because it was brought up to me just a few moments ago by my colleague next to me, that if, particularly with revenge porn, if the act is still going on, if it's out there, even if you didn't know about it, then the act is still happening. The illegality is still happening. So there's no need to remove the statute of limitations, because unless you want to say that if it was taken down and it doesn't exist anymore, but then 50 years later, you should be able to charge them. That to me doesn't make sense, as Delegate Conaway said. But if it's been sitting out there for 20 years and you just discovered it, then the statute hasn't even begun to run for the year. That's different than stalking, which has a time period.
Doesn't apply as a default. It's when the offense.
It's when it's from when the offense was committed as opposed to when the offense was discovered.
Unless specifically provided, like we just did in the other bill.
So I guess then the question, going back to Delegate Carden, is if your point is that it's almost like a continuing crime that if it were revenge porn and it was done in year 1, but it was seen in year 6. Is that the point
Right,
you're
then
making?
you could, then, once it's discovered, I think there should be a statute of limitations, but it's not, it's, as long as it's out there. And if it's still continuing, it wouldn't matter if it's year 6 or year 20, it's still out there because it's a continuing crime. Right? If you're continuing the crime, then the statute doesn't start running when you discover it, does it? If it's continuing?
What he's saying.
I don't know. I'm asking the question.
Yeah. Okay, I want to take a breath on this one and I'm going to hold it just because you've got my head going in circles and there's I don't want to sit too long on that one, but I'm not gonna sit too long on that
Yeah,
one.
no,
But
that's fine.
I do want to kind of think that through a little bit. That's fine. All right, let's go to 589. Dorchester County Delegation. Do they have a letter? And there's an amendment. Oh, no. Wait a minute. One moment, please. I don't have the file. I don't have 589 for what it's worth, so I don't think there is an amendment, but all right. So this is just giving them the opportunity to do polygraphs on Delegate Moon.
I'm gonna,
Not on Delegate Moon, I'm just saying, gives them the opportunity to do polygraphs on employees, not polygraphs on Delegate Moon, but I recognize Delegate Moon.
thank you, Mr. Chair. I'm going to vote for this bill, for respect out of local courtesy, but I do want to flag that my spider sense was tingling during this bill hearing. And I was talking to my friend who sits next to me, who also recalled, both of us, that Paul Quarterman, then a delegate, was in here trying to get rid of his county's polygraph requirement. And I just want that out on the record that we shouldn't, I mean, this is not just let's just pile on my county onto another bill, that there appears to be unintended consequences when counties adopt this policy. So I will leave it at that, but if the county wants to go in this direction, I'm gonna vote for it.
Okay. Could I have a motion on the bill? Second, all right, this would allow them to do polygraphs for paramedics, EMTs, a 911 dispatcher, or a correctional officer at the detention center in Dorchester County. Further discussion? Seeing none, the vice chair?
Yes.
Yes, Crutchfield?
Yes.
Yeah. Yes. Carden? Yes, Embry? Yes, Pasteur? Yes, Tolles? Yes, Schmidt? Yes, Boucher? Yes, Phillips? Yes, Roberson?
Bless you. Roberson, you wake over there?
Roberson, no. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson?
They don't work. Okay.
Yes. Is it a yes, or tell me what it is? It's a bleh? I don't know what that means. Yes. Delegate Grammer? Yes. Moon? Yeah, yeah. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams?
They want to do it, yes.
All right.
How many people are in that?
3, I think.
That's what I'm thinking.
Speaking of Dorchester County, Delegate Hutchinson has a bill.
Yeah.
589. I send this to you? Okay, Delegate Williams, there's an amendment.
Amendment, there is an amendment to add in cemetery elements. And it's adding the word statute of limitations and prohibition. And so just also adding in some language to just state to begin at the time when the local authorities knew or reasonably should have known of the violation, and prohibiting a person from willfully destroying, damaging, defacing, or removing landscape or part of the grounds of a cemetery. So part of this, the impetus of this bill had to do, I think, with some funerary objects, might have been in the Delegates County, I can't remember, but then he also heard from a cemetery in Baltimore County, which is where the request for the cemetery elements came from, to also address a situation that happened in Baltimore County as well. So,
Yes, there's a motion and a second on the amendments that were just described. The vice chair.
Yeah.
okay.
On the amendment, right?
On the amendment. You want to talk about the amendment or the bill?
Well, I just want to make sure I understood the amendment.
Yes.
So on the, in the hearing, I thought that the family had transferred the property, actually sold the property. So I'm trying to figure out what was going to give them, did they have like an easement on the cemetery or something? I was trying to figure out why they had rights to the funerary.
They transferred it. I thought they just hadn't been to their loved ones. for
I think they
even a
just
year.
hadn't been to the loved ones.
Because of
Yeah.
COVID.
Yeah, I think they just hadn't been to the cemetery in quite some time. And when they finally did go to the cemetery, I think they noticed some of the headstones or something were defaced, were vandalized.
Okay, so,
Oh, bulldozed.
yes, that's what I'm trying to understand. So, okay, thanks, everybody. But here's my question. The property rights of the cemetery, who did those property rights belong to?
I don't think that was.
No, I'm asking because the reason why I'm asking is because we're saying that the local authorities knew or should have known that there was a violation. I'm trying to figure out, how does the local authorities even get to be a part, standing on this if we're talking about someone's property? I'm hearing that cemeteries are public, but I need to understand that. That's all I was getting at. So who owns, what gives the local authorities standing with
It would
respect to
be-
a violation?
I think it's the report of the violation to the local authorities. And it's that point where the clock would start to tick. Because at first it was a 5-year window. We lowered it down to a 3-year window in terms of the statute of limitations. And so the window would, in terms of the local authorities, that time frame would start to tick at the time when the vandalism is reported.
Okay, so actually that case is totally separate from this the real issue that's going on in this bill.
Yeah.
Okay, thank you. I
Mhm.
appreciate it.
3 years.
Make it 3?
Yeah, it was originally 5 years. The subcommittee lowered it to 3 years.
What was it before the amendment? 1
1
year?
1 year. It was 1 year beforehand.
Delegate Taylor, then Moon.
Just for clarification, the statute of limitation was 5 years, right?
Well, in the original bill, it was 5 years. When Delegate Hutchison introduced the bill, he had proposed the statute of limitations to 5 years. The subcommittee reduced that down to 3 years.
Okay, thank you.
Then Moon, Delegate Moon.
Thank you, Mr. Chair. Well, I just want to flag, this is the third statute of limitations discussion we've had in a few minutes, and it's got me now, I like to conform things to one another. And so I guess we have one where we did it 5+ discovery of the offense, and we have on other ones, we're pegging it to the actual date of the offense. Doing it to discovery does, as Delegate Conaway points out, create an infinite world of possible statute of limitations, and pegging it to the date of the offense. We could just go longer out on when we're doing things pegs to the date of the offense if we're concerned that we're not going to capture things. But I just want to flag this dynamic since I've got my professor patches on today.
Professor Patches.
Delegate Conway.
Chairman, I had a question about defacing the property.
Yes.
If in certain cultures, people might put stones and other things on top of the headstone, like actual rocks. And if a person goes into the cemetery and moves those rocks that have been placed on the headstones or on the grave markers, would that come under this bill?
I mean, if they may determine that the headstone had been defaced. I mean, it doesn't necessarily mean that the person's gonna go to jail. There would be a trial to determine that,
Yeah,
but
so you could be charged. Well, I mean, you could be charged. If you said trial, so the only way you can get to trial is to be charged.
That is
As
true.
I know it.
right,
As I know it. So therefore, you could be charged. potentially.
possibly.
Okay.
The photos are in for, trying to remember it, the photos are in here.
Oh,
No, I know somebody that moved some stones off of a gravestone marker that was in a Jewish cemetery. So that I know that for a case in another culture.
All right. We had a motion and a second on the amendments. Is there further discussion on the amendments? All right, all in favor of the amendments, raise your hands. 1, 2, 3. Okay. Anybody opposed? Conaway? All right, we're on the bill as amended. Motion for a favorable and a second. Further discussion? Seeing none, the vice chair.
Yes.
Yes. Crutchfield.
Yes.
Yes, and an add. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes, and an add. Roberson? Yes. Tomlinson? Yes. Erican? Yes, and an add. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? No. Kaufman? Yes, and an add. Williams?
yes.
Yes. Favorable is adopted. Right. House Bill 723. Are we second? We are second on House Bill 723. And here comes Holly, who will tell us what is in 723 as it is in its present form. Holly, please.
Okay, so this is a joint bill. As Chair said, we are secondary. HGO is primary, and this voted out of their committee unanimously. So this bill authorizes the Attorney General to seek injunctive relief on behalf of the state on the basis of one of the amendments is going to deal with the harm, but on a imminent and ongoing violation of a specified basic right for residents of facilities or assisted living programs. HGO amends the bill to specify the Attorney General may seek relief only to prevent irreparable harm to the residents and specifies the AG may not duplicate any corrective action that is imposed already by the department for the same action. The majority of the testimony was favorable, and we sent delegates Embry, Taylor, and Tomlinson for this hearing. And the AG is okay with the amendments that HGO made.
Seconded on the amendments. All right, any further discussion, Delegate Eric?
Sorry, do these amendments conform it with the way it left HGO, or these are our personal amendments?
This is HGO.
This is HGO. HGO made the amendments.
Okay, so.
So
and that's in-
we're basically, I haven't gotten anybody else who's offering an amendment here. So we're basically doing a favorable on the bill as HGO amended it.
Yeah.
So we're not adopting, I don't think we have to adopt their amendments. We just
No,
go
we're-
straight to
We're
the
voting that
bill.
you
We're
approve
voting
that.
on the bill as they amended it.
Is that in our packets, and if so, can somebody? take
Yeah,
the
it's all
page?
the way at the end. It's
At
like,
the very end?
well, not at the very end, but
48,
maybe
okay.
like 4 pages up.
Okay, Okay,
But it's
Okay.
the you're gonna see the reprint in there. I put the reprint so you could see the changes.
okay, okay. And then was there any changes made to the actual rights? No. it
No,
looks like
none
it's
of the
same.
rights were changed, and the Attorney General can only bring a case for those basic rights that are listed and outlined in the bill.
Okay, all right, thank you.
Delegate Kaufman.
I just want to make sure I heard correctly, because maybe this will help Delegate Erican or other things. You said that the bill passed HGO unanimously, correct?
Yes.
She did in fact say it's passed unanimously. All right, questions, Delegate Valentine.
Thank you, Mr. Chair. Do those rights, I'm reading on page, and I don't see what page it is, because okay, I don't have the reprint, but on page 4, that includes the minimum for the resident Bill of Rights, the right to be treated with consideration, respect, and full recognition of human dignity and individuality. So could they bring a resident that actually feels that they're not being respected? Is that's included as just one of the or is that a element or one of like several elements?
As I understand it, it's any of the basic rights provided. It looks like it says, hold on.
I think the critical language in what would trigger a violation is to prevent irreparable harm. I think it would you have to show irreparable harm, and I think that would not be, that would require there be something more than an individual case where somebody wasn't respected. They would have to demonstrate something significant that happened.
More than simply that.
Irreparable meaning something they have been permanently harmed in some way. And I don't.
And that could be physically or emotionally, or
I guess the most likely way would be that it would be something physical, because you'd be at least able to demonstrate that there was an irreparable harm, something that could not be repaired, harm that occurred in that case.
And if you look at the testimony, it seems like most of it revolves around care. The care, the services that are being provided, that's where a lot of the testimony revolves around residents that have been mistreated or abused or left for extended periods of time, for example, without getting the right care that
care, physical abuse or lack of care itself from a physical standpoint.
And I'll point to the other part of sort of the thou shalt not section in saying that the authority given to the Attorney General can't duplicate the authority that is given, I think, to the health department, right? It's to the people who are regulating. So if the regulator is doing something, the Attorney General can't pile on. It's one or the other.
Okay.
Delegate Erican.
Holly, could you tell me, is irreparable harm defined in statute? If not, is it a term of art? And where should I look to figure out what that actually means?
What word?
Irreparable harm. Is it defined in statute anywhere? Is it just a term of art?
I would think it's defined, right? At least in case.
It would certainly be in case law, but
Yeah.
irreparable harm, I mean, yeah, this is what we get into with.
I mean, this job has irreparably harmed me, but can I sue over it? I mean, let's be serious. Let's be serious. Okay, last terms committee. This one's greatly improved.
I mean, I can ask HDO's counsel.
If you'd like us to hold on to it for a second, I mean, look, it's a reasonable question.
Yeah.
It's a reasonable question. I believe irreparable is, well, irreparable. It means it can't be repaired. But a harm that can't be repaired, which makes me think it's not an emotional harm, but yeah, for the record, Delegate Erica just pointed at her head and said, can't fix this.
Yeah.
All right. So anyway,
Where's our therapy dog? Come on, we've requested it for years. We have been requesting this for years.
We haven't had a therapy dog, and if this is about that, I'm fine. I'll work on that some.
No, I really am a little concerned. So the department has the opportunity already to get a lot of this stuff. And so now we're adding the OAG. Okay, what are they going to actually be doing? Because most of this stuff is stuff that would be a violation of health code already. that feelings bit at the top, that's all we got that I'm looking at. So and I don't like it. I just don't like it. I think it's weird. So.
just a bill of rights. I don't think
But we can sue people now, and it's not the victims, it's the state, and I don't love
Right, so-
it.
Right, so you're getting injunctive relief
Mm-hmm.
for irreparable harm, which
Of someone's
It's a
human
higher-
dignity.
which is a higher standard. I think you'd have to stretch pretty far to get that, but we're trying to get an answer as to irreparable harm, but
Yeah.
maybe the vice chair just found it, and I think she did.
Yay.
Here she comes, vice chair.
So irreparable harm is harm that cannot be compensated by a monetary award or damages. And it is necessary to have injunctive relief or a preliminary injunctive or temporary restraining order to at least, that's like the only remedy you have.
Okay,
Yeah.
okay, yeah, I like it less now. Sorry, guys.
Did you want that?
No, I think that's very helpful, but it's also causing me to think of some situations that I went through over the last interim. Delegate Grammer.
Thank you, Mr. Chair. And I just wanted to voice some of my concerns about particular cases that have happened in the state, and I think maybe causing some angst with the bill. So if you remember the issue at St. Joseph's Hospital they had a young person that was mistakenly scheduled for a treatment at St. Joseph's Hospital, which is a Catholic hospital, and they were mistakenly scheduled for a sex change surgery. Well, being a Catholic hospital, St. Joseph's doesn't provide that. They were subsequently sued for declining that particular treatment because they don't do that, and they ended up having to affirm that individual's care based on the suit. And if you're reading through like the individuality, like if I identified as a woman and I said, you know, I'm having irreparable harm because I'm being denied care based on my individuality, these kind of things, sex change surgeries, hormone blockers, these are the kind of things that the state can really just come down on an institution for. And I think, you know, a lot of the issues that are probably covered in the bill, you know, just protecting patients, I think that's very noble and just, and I think there's a lot of mechanisms to do that currently. But what we're doing here is we're empowering the Attorney General to really drill down on a lot of these cases. And as we've seen in this state and across the country, a lot of this has really been punitive. So, you know, I have some angst here. I think that the administration of justice, particularly with the attorney generals across our country, has really become political. And that's why I'll be voting against this bill.
All right, so just to be clear, what we're talking about here are nursing homes that admit patients suffering from disease or disabilities or advanced age requiring medical service and nursing service rendered by or under the supervision of a registered nurse. So this does not extend to every hospital in the state of Maryland. It doesn't extend to clinics in the state of Maryland. It only extends to nursing homes. And let me tell you, I've seen some stuff over the last year that makes me feel like there need to be more eyes on this, not less. And seen some facilities that my family had to visit that there needed to be more eyes, and they needed to make sure that the care and dignity of the people who were there was looked after and attended to. And I think that's the point of this bill. I don't think it goes beyond that. And I think that makes it, in my mind, a fairly good piece of legislation. But Delegate Conaway.
Thank you, Mr. Chairman. Just, I appreciate your explaining what you went through. I can say that most of you know that I had a new hip replaced. And yeah, during that time period, I was told that I was impersonating a guy named Delegate Conaway. And I was almost put out of one of these facilities for impersonating that guy because I couldn't be a delegate. So thank you very much.
Okay, so I just wanted to also state that the, as we were talking about irreparable harm, and we're talking about this adjunctive relief under, under 19 dash 343, the sections that are referenced there are basic. I mean, I had to look them up to see what they were. They're basic rights, such as the right to receive treatment, care, and services that are adequate, appropriate, and in compliance with the state and federal laws, the right to privacy, the right to be free from mental and physical abuse. And can go on, but I won't. But the point is that that would be the injunctive relief, because you can't really put money on the fact that somebody invaded your privacy necessary, or you can't necessarily put money on, the right to receive treatment. So this would allow, and it already is part of the law, where the Attorney General already has the ability to go in under 19-343 under the Health General article. So it's basically just saying that it was the General Assembly, to promote the interest, but the Attorney General would have the right to seek injunctive relief when those things are not happening. So to go to the healthcare facility and demand that they give, proper treatment or proper care or proper services, et cetera. With the example that Delegate Grammer was giving, there actually could be monetary relief if someone wants a particular operation, they're not getting it, they would go somewhere else, they would get that operation, and then they could sue for the cost that it costs them to get the operation somewhere else. So there would actually be a monetary relief there. So that's what I wanted to add.
Thank you, Mr. Chair. My only question is, aren't there mechanisms in place in different regulatory agencies that should be handling this? I guess, why do we need to expand it? I know that there's already current law for the Attorney General's office and so I'm just feel like it's being expanded.
So there actually is an oversight board of nursing homes, and they existed during COVID, but it's a bureaucratic, no offense against the bureaucrat, because that's who we are, but it's a bureaucratic system. They have to meet, they have to, and they only meet, I don't know how many times a year, whereas with the Attorney General, they can actually go in quickly and expedite a temporary restraining order in some cases as they would need to, and it wouldn't have to wait until the person is deceased and they later find out, oh yeah, we really didn't do, great care here.
Delegate Cardin.
I mean, I'm actually looking at the bill, believe it or not. God. So as the Vice Chair said, it only allows them to ask for injunctive relief. I think it takes out the penalty part. So they can't even sue them for money. This is just requiring they are now allowed to go in and try and get them to treat these people the way that they should be treated. I'm looking forward to being a co-sponsor on this.
Thank you, Mr. Chair. Now, in the preamble, it mentions assisted living, not nursing home, no other facility. So when we are referring to facilities here, are we only talking about assisted living, or are we talking about the gambit of facilities, healthcare facilities? So, and I'm also reading that the Residents' Bill of Rights is associated with, and maybe I'm wrong here, both assisted living and other healthcare facilities, but the certain civil penalty is on the assisted living only.
So I think part of this is you're looking at existing law.
I am looking at existing.
Yeah, so there's that part, but then you have the next part where they're adding that into the assisted living, I guess, into the assisted living section.
Yeah, on page 3 of 5.
Page 3 of 5, correct.
Right, it mentions residents.
But they also include, again, that the irreparable harm language is also in the first part as well. Am I reading that? So there are two pieces to this, and I think that one piece is the nursing home piece and one piece is the assisted living piece. Am I reading that right?
So hold on, I was looking,
Turn on your mic. Oh, your mic is on.
yeah, mm, yeah, Chair, I think that's right. I think that's right.
What she thinks what's right. I didn't understand.
There's one
her
part
answer.
that deals with nursing homes and the next part deals with
With the
assisted living.
assisted living, so it's two parts.
Two
You've got
pieces.
19-1805, and then if you go to the new provision in 19-1805.1 is where, so it looks like, and again, I'm happy to talk to Erin if she's the co-counsel in HGO if there are questions.
Okay, I just wonder if there'd be some, some confusion on the part of whomever has to interpret this at some point, because nursing home is different from assisted living, which is different from rehab facility, which is
Yes.
different from, right?
No, that's right.
So, yeah.
That's right.
Yeah.
Delegate Erican, then Valentine, that I think we're gonna need to wrap this or get it closer to a conclusion.
Yeah,
Delegate Erican.
so I'm just looking at page 4 of 5 or page 51 of 76 in the packet. It does say specifically the patient bill of rights, resident bill of rights is only for assisted living
Assisted
program
living.
facilities. And again, I actually think it's a fabulous thing to do. I really just don't like lines 3 and 4. We could redraft them and honestly, what we're really talking about in there is emotional abuse. I mean, if you're emotionally abusing somebody, you're not treating them with dignity, and that feels a little bit more concrete than this sort of squishy amorphous thing that we have in 3 and 4. I mean, it's feel good, but I just don't like it. And I don't think it's tight enough. And so, if we didn't have that in here, I would absolutely be green and co-sponsoring this because I think it's important, but I just really can't with that number 1 on lines 3 and 4.
The vice chair.
Well, I'll just say that the reason why the Bill of Rights is listed is because we actually have in law and we required assisted living facilities to establish a resident Bill of Rights. I don't know that we've done that previously for nursing homes. And so we didn't call it that. It's actually just enumerated, as I mentioned before. But in assisted living programs, we actually required the secretary to establish a Bill of Rights. I don't think that changes your position, but I just wanted to tell you the difference between the two.
Email from the chief affairs unit for the AG, and she said that this is for criminal conduct. It's not about regulatory issues. Those are what the board that vice chair was mentioning, the OHCQ handles all of those. This is for nursing homes and assisted living facilities, strictly for individuals who cannot take care of themselves. And that's the definition that chair was reading earlier. And then she says it is for both, but again, it's defined for those individuals that are at limited capacity.
Valentine.
Mr. Chair, and I apologize. This is the first I've read the bill since it was in HGO, so I did not have any of this information. So I'm just trying to clarify the points. So to go back to Delegate Cardin's point, this is not, and I believe you just said what I was going to ask was this is a criminal, not civil, so they won't be going after them civilly. And I think is the last line about the, I don't know if this is in the reprint. I'm looking at the original bill about the imposing of civil penalties not to exceed is they were stripped. I'm sorry, I didn't have the reprint. So thank you for answering all these questions.
It's taken out. That's
Thank
right.
you.
All right. We have gone round and round. Is there a motion on House Bill 723? It's a favorable and a second. All right. We have had extensive discussion. We are agreeing with the bill, and the motion is to agree with the bill as amended from HGO. All right. The vice chair.
Yes.
Yes. Crutchfield. Yes. Yes, and can't do that. So Speaker Bill. Cardin. No, you can't. Embry. Pasteur. Yes. Tolles? Yes. Schmidt? No. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? I'm sorry? No. Erican? No. Taylor? Yes. Simpson? Okay. Grammar? Respectful, no. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman?
Yes.
Yes. Williams is out. Well, let's just make sure. 6, 9. Yes, okay, we're good. Motion's adopted. All right, we are at a point where there are a couple other bills that I think are gonna take less time. And we'll see about this, but we're gonna try and get through a couple of them because I'm just putting everybody on notice. We're probably coming back after at this point. House Bill 1037, 1037. Delegate Taylor's bill that Delegate Simpson is celebrating about prematurely, but there are amendments, but there are 3 amendments. Are there 3 amendments or how many amendments do you, are, what? There are only 2 amendments. All right, can you explain the amendments,
I
Delegate Taylor?
certainly will.
What are the numbers at the top, please?
363-820/1.
You mean 423836380. Got it. Okay.
Okay, got it? So the First Amendment adds the Attorney General or the Attorney General's designee to the list of members to the task force. It also moves the collaborative, the Maryland Equitable Justice Collaborative from one section of membership to another. So the Attorney General wanted it to be added underneath the Attorney General's designee. And then the Second Amendment, it brings the bill in conformance to the Senate bill. They added a member of the task force serves at the pleasure of the person who appointed the member, which is language that I'm okay with. And then a second piece of that is that the task force shall adopt a code of conduct at its first meeting, and I'm okay with that as well.
All right. There's a motion and a second on the amendments. We'll have discussion. One moment, please.
There's one other amendment. Okay.
There's another amendment?
Yeah, actually, the one I just
We thought you had a third one.
I do see a third one here.
Okay.
Yeah, I forgot there was,
It adds
they
a
weren't
member of public
combined.
Safety
Yes.
as a member is what
Yep,
Claire
that's
said?
all. No, we added a member of the Division of Parole and Probation, DPS.
Okay, so you add in the third amendment, a representative from P&P, from Parole and Probation.
Correct.
All right, so motion on all 3 of the amendments and a second. Any discussion on any of the amendments that are being offered? Seeing none, all in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Anybody opposed? All right, amendments are adopted. Motion for a favorable on the bill is amended in a second. Any further discussion on Delegate Taylor's bill? All right, the Vice Chair.
Yes.
Yes. Crutchfield.
Yes.
Yes. Carden. Yes. Embry. Yes. Yes. Add-on for Embry. Pasteur. Yes, and an add. Tolles. Yes. Schmidt. Yes. Boucher.
Oh,
Yes, look at that. Phillips. With it, did you want an ad or just with a, okay. Well, that's all right. Well, we double check. Phillips? All right. If you're not, we'll put you on again. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? An excited yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes, and add. Kaufman.
Yes.
Yes, and add. Williams.
Yes. We switch study and, yes.
Yes, and add on.
Yes, and add.
Yeah. Crutchfield adds, Williams adds. Okey dokey. That was 10:37. Oh boy, let's do another local bill, 1093. Kind of digging down here a little bit, 1093. Local bill, have a letter, the delegation vote was 10-4. Allowing their Human Relations Commission to get, to do subpoenas, if I'm reading this correctly. All right, there's a motion for a favorable and a second. And this is 1093. There are no amendment. There are amendments. Oops. So we'll roll that back. Okay. Oh, there are amendments in your packet, 843921. Blair, can you tell us what the amendments do?
The amendments alter procedures to be followed by the commission and the court when a person fails to obey a subpoena served by the commission.
All right. Questions with regard to the amendments? Delegate Erican?
Does it still have a body attachment with the amendments? Because that was my.
No,
problem.
it's punished through contempt, through the contempt process.
Okay, so
Takes
you
that
could
out.
still be remanded though to serve some overnights in jail if you don't show up. Because
It strikes the body attachment.
that's good, because that was weird.
You could be held in contempt, but yeah, I mean, judges, I guess in theory, yes.
But still less bizarre than
Less
having a
the
body.
body
attachment.
attachment where they're tracking you down, they're sending, yeah.
Yeah, okay. Cool. Well, I like the amendments, I'll tell you that.
All right. Further questions about the amendment? Seeing none, all in favor of the amendment, raise your hands. 4, 5, 6, 7, 8, 9, 10, 11. Anybody opposed? Amendments adopted. We're on the bill as amended. Motion for a favorable. Is there a second? All right. Any further discussion on the bill as amended? Seeing none. The vice chair? Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons is not here still. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Looking at your neighbor. Okay. Motion's adopted, just making sure. I was just, I was making sure. House Bill 1081. There are amendments. Wait, we need to, do we need to do something?
An amendment from the amendments office.
Yeah, okay. I'm gonna hold off on that
Okay.
because I'm gonna try, I wanna try and still make some time here. Let's see what I can do. let me see what I can do outside of that. We're gonna go instead to House Bill 1086. 1086. There's an amendment. There's an amendment. It was an amendment requested by the Office of the Attorney General, if I'm not mistaken, looking into the audience a little bit for a sign from above. It adds a crime for which people can receive compensation if they were erroneously convicted of a conspiracy to commit a felony. I believe as it stands right now, you could only receive it if it was a felony. This would be a conspiracy to commit a felony. And as I understand it, the total number of people that this would cover would be two. Not three, two. There's a motion on the amendment in a second. We'll have discussion. Any discussion on the amendments, Delegate Arakan? Not on the amendment. All right. Anything on the amendment? And then we're not there yet, but all in favor of the amendment, raise your hands. Yeah, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? One. Amendment's adopted. Now on the bill as amended, is a favorable in a second. Okay, discussion now, Delegate Eric.
Thank you, Mr. Chair. On page 3, it removes a chunk of code, line 7 through 11, where it says an individual may not get compensation if for any period of their confinement they were concurrently serving a sentence for a conviction that was lawfully convicted and confirmed. I'm a little bit uncomfortable with that and wondering why are we removing this? Because in my mind, it's a little bit odd to say someone was rightly convicted of something and we're going to be compensating them for a time period they spent in jail that was concurrently being served for a crime they actually did commit.
Delegate Moon.
So if I understand the question, I think the scenario it contemplates is maybe you had drug possession and the other offense that you were exonerated for, and you did time for both. That just because there was an actual conviction for drug possession, which you did, if you were wrongfully accused of murder or rape, that shouldn't stop you from getting compensated for that time.
Yeah, I hear it. I just, why? I mean, again, these are concurrently being served, okay? There's no additional.
But it might be a lot more, you might be doing a lot more unwarranted time on the offense that you got exonerated for.
Then you're not serving it concurrently anymore. That term died off and you continue to serve your term for the other thing that you were erroneously convicted of. And you can get compensation for all of those erroneously convicted days, but you shouldn't be compensated for the days that you were serving for the drug charge that you rightfully were caught with. I mean, that's not reasonable in my mind.
Pro rata, okay.
Delegate Card.
You, Mr. Chair, maybe as a prosecutor, you can,
oh boy,
you can enlighten us. But so if that scenario comes up and let's say you got convicted of 2 different charges, one was a drug and one was for attempted first-degree assault, and you wound up getting 10 years. Let's make it easy. And you proportion it. The first degree assault was a wrongful conviction, but that maybe was 75% of what the judge was thinking, right? And 25% was for the drug charge.
Mm-hmm.
So how would the Attorney General then say, well, we're only going to are they going to try and compensate you for all 100%? Are they going to compensate you for 75%? Are they going to compensate you for, and say, you know what, you don't even deserve 75. We're convicted of something. So we're just going to compensate you for 10%, or is there a formula in the bill that requires them to compensate for a certain amount?
Well, helpfully in the interlineated copy of the bill, it just turns out that the language that Delegate Arakan is looking at is just in a different place. It says on page 5, they just move the language to say subject to subparagraph 2 of the paragraph, an individual may not receive compensation under the section for any period of confinement during which the individual was concurrently serving a sentence for a conviction of another offense. So they just moved the language.
I don't think we have an interlineated copy here. No. Okay.
But
So
that's
how did it get moved?
Well, they picked it up. So the.
You're killing me, Smalls.
um,
Killing me. Okay, so it is still in there and so
No,
the
it was in
concept
the,
is still
it
intact.
appears to be in the bill as it was initially, it was initially, so I'm.
Yeah, I mean, it was removed, so it's.
Yeah, it's right there. It's on page 5. It's on
Okay.
page 5 as the bill was introduced between lines 11 and 15. They just moved it. They moved it to down the line there a little bit.
Where? You said page 5, what?
Page 5 of the bill is as it was introduced.
Mm-hmm, and,
Subsection 4,
okay.
lines
May-
11 through
May
15.
not receive, okay, for any period of confinement.
So they're just cleaning it up.
Okay, there's, yeah.
They're
moving
cleaning
around.
it up.
Okay, all right, I like it then. Not the whole bill, just that piece.
Okay.
All right. Okay, like.
All right. Great. Did we do the amendments?
I don't remember.
Yeah, we did the amendments because okay. So, all right, there's a motion for favorable and a second on the bill as amended. And so, great, I don't see anybody else. The vice chair?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
Okay, if you would hand that back to Holly, please, and I can do this, put this in here, and I can scratch that off. 10:45, or you wanna wait? You wanna do it, or? We still have to figure out a fiscal note thing with them, or whether, yeah, we kind of do. All right, well, we can't do that. I'll kick it to tonight and we'll figure that out. We'll go to 892, Delegate Kaufman, and another bill back-to-back days. I don't know what's going on. Who runs this place? There's a motion for a favorable. This is a benefits. Oh, wait, there are amendments. We need to do the amendments then, don't we? And did this go to subcommittee? David's subcommittee. Does David want to talk about the amendments to 892?
Sure. There were
Great.
3 amendments. One of them came by request of the state's attorneys and some advocates, and it alters the bill to be about benefits exploitation as opposed to trafficking. That was one change we made, and then the other 2 was a sponsor amendment and an MDH amendment to simply add more benefits into the scope of the bill. Move the amendments.
Any further questions? One, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Anybody opposed? Seeing none, the amendments are adopted. We're on the bill as amended. Is there a motion? Motion for a favorable and a second. Any further discussion? Don't see any. The vice chair?
Yes.
Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles?
Yes.
Yes. Yes, and an add. Schmidt? Yes. Boucher? Yes. Phillips? Yes, and an add. Roberson? Yeah. Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yeah. Yes, and an add. Kaufman?
Yes.
Yes. Williams?
Yes, and an ad.
Yes, and an add. All right. Moved 892. All right, everybody, here we go. House Bill 763. House Bill 763. Does it ever have an amendment? All right. Now, this was a very difficult hearing. Could I ask for another glass of water here real quickly, actually, because I'm dry. A very difficult hearing and a very difficult issue. So what I am proposing in the amendments 503023, and you should have an interlineated copy of the bill, is to two things. One is to strike from the bill any of the organizations representing groups that are covered by the hate crime statute, and simply saying that the Attorney General gets to appoint 15 individuals who represent or advocate on behalf of individuals who are members of a protected class under the state hate crime laws as set forth in Title 10, Subtitle 3 of the Criminal Law article. Further, it sets it sunsets the task force. It sunsets, the commission on June the 30th, 2027. So what would happen would be that the next General Assembly would have to take this issue up. They'd have to see how this commission operates and how this commission runs, how the Attorney General runs the commission, and makes a decision at that point as to whether they want the commission to continue or whether it shouldn't continue. I don't think there is an easy solution to this at all. And I will say, if anyone is watching still at this point, maybe some people are, I don't know. To the groups that were listed there before, I would say that what we're doing is we're basically saying, in conjunction with a bill that the Health and Government Operations Committee passed, that deals with the rights of the people who appoint people to these groups, and sort of the rules of the road of when they can appoint, when they can remove people from there, that it would be more appropriate to provide broader discretion and let the Attorney General decide who those people are, and the Attorney General will be in a better place to determine what part of the state they're from and ensure that the different protected classes are covered. And so that is the amendment that I am offering to the bill. There's a motion. And we add the Office of the Public Defender to the task force. None of that. All right, come on. So there's a motion and a second on the amendment. We see Delegate Tomlinson with a question.
Thank you, Mr. Chair. Just to be clear, and because I'm scanning through the amendment. So for example, are you saying instead of saying somebody as one representative of the Baltimore Jewish Council, you're saying the Attorney General will appoint just in general a member of the Jewish community?
I suppose they could be a member of the Baltimore Jewish Council. It would be up to the Attorney General's office. The Attorney General would, the requirement is that they as I don't mean to read and repeat, but that there are 15 people who represent or advocate on behalf of individuals who are members of a protected class under the state hate crime laws. So
okay.
They could be a member of the BJC. They could be a member of any number of different groups. And we don't go into that at all. But I think the thought here is, by keeping it wide open to some degree for the Attorney General, that this bill now, in conjunction with the overarching bill that was passed by the Health and Government Operations Committee, gives the flexibility for the Attorney General's office to be able to do what they need to do and appoint people as appropriate to this commission.
Okay.
Delegate Kaufman.
And yes, I just have a question, and I intend to support the amendments, and I appreciate all your work. But just to make sure I'm understanding, because the amendment packet was big, so I couldn't read it thoroughly. So your amendment does nothing regarding conduct of members or different things because that's a separate bill.
That was a separate bill, and the Health and Government Operations Committee already took up a bill, addressed that issue. I will say that we are 3 weeks, a little more than 3 weeks to go, and there could conceivably be more work that we're going to have to do on this issue, and it would not shock me if that were the case. But we don't go into the conduct issue here because in the bill that was passed out of HGO, it addresses those issues and addresses not just this commission, but all task force work groups and commissions generally.
Okay, no, I support you. I was just confused. There've been so many bills flying across the desk. So.
Yes, there are quite a few going across. Delegate Phillips, and then I'll go to Cardin actually. Phillips, Cardin, and Taylor.
Mr. Chair, the way this is written, it does concern me a little bit, and I understand what you're attempting to do. 15 individuals who represent or advocate on behalf of individuals who are members of a protected class under the state hate crime law would suggest, or could be interpreted, I could take 15 members of the NAACP. You're leaving it to the AG, I understand, but that is a little, or there are protected classes in which I might not have anybody represent. That's a little concerning from a intent, if it is an intent to have various thoughts and ideas, etc., that is a little concerning.
And that's something that I thought of and thinking about the language, and I don't know that there's a perfect way to thread this needle. I think I can go with the one, not meaning to be crass answer, but the Attorney General is elected every 4 years and is going to have to answer questions if it was one group and not all of the others. Certainly the spirit of the commission is to have as many different people from different groups to be covered. That's the whole point. And it was certainly the point when individual groups were identified. I think certainly the other sort of the flip side of that is you could have somebody who is LBGT and African American. You could have somebody who you could have people who are in multiple protected classes. And so again, I think by leaving it to the Office of the Attorney General to go through and vet these people and to have some confidence in the Office of the Attorney General to find a diverse group of people to serve on this task force, I'm going in that direction at this place. And by the way, I think further it's consistent with what we're broadly doing in giving authority to whoever the appointing authority is to remove those people if that should need to happen in the future. And so that's kind of why I landed the way that I did. Delegate Cardin.
Thank you, Mr. Chair. And thank you for your hard work. I'm going to support the amendments. I don't see it as a perfect solution, but I will say that the HGO took most of the language out of my 748 to make theirs a statewide bill that basically dealt with this. However, I'm still unclear as to whether the code of conduct language is adequate over there. So that may be an issue that's coming up that's not addressed here. So we can continue to explore that. But what you just said about the AG is that, like, the AG basically threw it on us and said, I can't remove somebody because it was a political issue for him. Let's be perfectly clear. So we are now putting the onus back on him that he's got to have some courage to do what he believes, or she at some time believes is correct in how they appoint and do it the right way. And so I think that's not such a bad way of going about it. And it does sunset after 3 years or so, or 2.5 years. So we can revisit this at that time.
Well, again, let me reemphasize the sunsetting part. I thought about that long and hard because I mean, we passed this just last year. We passed this last year because the goal was to have a group of people from across the state who could look at what was happening in law enforcement in particular and see what was going on with hate crimes across the state. And I would like to see them actually get to their work. It would be the important part that I hope that they're able to do going forward. And I feel like my tone is a little wrong with your remarks. I don't mean to be, I don't mean to be that way. I'm just saying it also measures a little bit of my frustration kind of with the issue as a whole. And so I'm hopeful that if it doesn't work, then okay, see you in 3 years.
And going back to Delegate Phillips' point, if in fact the AG can appoint a diverse group of people, then I would say shame, then it's going to become clear, and that's going to have to be an issue that they're going to have to take up in that office.
That's exactly right. I think, by the way, that is another reason why it's unlikely that one particular subsection would be likely to be picked, because we're going to come back in 3 years and we're going to be looking at this again. Okay.
15 individuals who collectively fully represent.
No,
No.
not right now. Delegate Conaway.
Thank you, Mr. Chairman. I just wanted to ask, because I'm looking this up on the computer, it's talking about a protected class, talking about race, gender, age, disability, or sexual orientation. So could you possibly enlighten me as to who is not covered as a protected class?
Whoever's not in Title 10, Subtitle 3, and I need to go and pull that up on the computer and just to be, because when I'm getting asked those questions, I want to make sure I'm not getting it wrong. Let's do that. And then we were adding religion on, and we added disability, I think, on, and for what it's worth, yeah, it's those groups that you just mentioned under Delegate Cardin's bill that we passed not that long ago. It adds religion and it adds disability. And so it would add representatives of those groups. It's worth mentioning that those groups, I believe, were in some way, well, certainly the different religious groups were covered under the existing law as it stands. It ties it back to what is covered in the Hate Crimes Act, because the whole point is to look at the commission that right. Yes. So if it's covered by the Hate Crimes Act, it's covered in the bill. All right.
Thank you.
Okay. On the amendment, it's motion and a second. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Anybody opposed? Amendment's adopted. We're on the bill as amended. Motion for a favorable. And now there's another point that was raised on the, and I'll go down this hole a little bit with regard to a code of conduct. There was language that was proposed at one point in my discussions, and I just want to acknowledge it, that would have gone to providing the Attorney General a way to remove someone if they had said something hateful or offensive. It was pretty vague as to what hateful and offensive language could be. And it ran into problems with advice from the Attorney General in that it runs into a First Amendment issue pretty quickly, because it kind of is a question of when are they making those statements? Are they making the statements in the world as a whole, or in their work in connection to the commission? And for that is another reason why I don't go into the code of conduct with the amendment, because I believe that's truly a separate issue that needed to be dealt with outside of this, with no disrespect genuinely to Delegate Cardin. Honestly, I think I've gotten to a point where I'm not sure, frankly, and I'm staring at the person for the Attorney General's office. Not 100% sure. I don't think they have a problem with it. If they did, he's nodding his head. All right, we're gonna take that as a yes and stop talking. Anyone else? All right, we'll go ahead and vote then. The Vice Chair, yes. Crutchfield. Yes. Carden. Yes, and then you're already on as
Here's the second.
you're the second. Embry, yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes, and an add. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes, and an add. Erican. Yes, and an add. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes, and an add. Kaufman. Yes, and an add. Williams. Out. The chair votes aye. Okay, that was 763. That's that one. Okay. We're gonna have to come back for 10:45 because we need to figure out a fiscal note issue. Yeah, we're gonna try and do 8:10 now. So while we have been talking and voting, there have been people who have gone back and forth, I think, with Baltimore County and the public and the police department there. And my understanding is that they can live with the language that's been offered by Delegate Moon. And so I just wanted to make sure that that was the case. They can. And so for that reason, we did adopt that amendment, adopt that language. So we're now on the bill as amended. Favorable on the bill and a second. Is there further discussion on the bill as amended? Delegate Eric.
Does it still criminalize the simple possession?
It says that it would be that it is a 3-year penalty. Yes.
Okay.
It says that it's a 3-year penalty. I will say that this morning, visitors to the suite may have noticed something on my door. I went to the range in Towson at Baltimore County, and there's video, as the chief of staff will tell you, of me using a Glock that had one of these attachments, one of these switches attached to the back of the gun. And it was an eye-opening experience. And members of the committee are certainly very welcome to see the video that Hunter excitedly took as I was firing the weapon. But on a pull of the trigger, multiple bullets were coming out of the handgun and on multiple different occasions. And perhaps a little more concerning while I was doing it, it felt like the gun was struggling to handle what was going on. And I'll say, I won't say that I'm a great shot, period, but I definitely will say that while that was happening, I felt my hands swinging left to right while these bullets were all back to back to back to back, automatically coming out of the firearm. And I had both hands on it, and I had the help of a Baltimore County police officer to make sure that didn't think it was going to go complete side to side, but at the same time, it was a very, very interesting. And I will say that they then provided the opportunity to shoot a rifle that went from automatic to semi-automatic to provide some framework. He took pictures of that too. So I'm just okay. So in any case, it was very helpful to see the impact of this very small, very, very small, and in many cases computer printed item that in some cases I understand is sent into the country and attached to a key ring to avoid being considered a piece of hardware for a gun. And with that, I will stop talking. Any further discussion on the bill? Delegate Erican.
That's my issue. How would anyone know that they even had it? So like, let's say you're in a DV situation, your spouse is trying to jam you up. They put 10 of these on your key ring. You have 10 individual charges for possessing these things and you don't even know what they are.
Well, but I'll tell you that they are unique enough and they're
They look
different
like a
enough.
paperclip.
At least for what I mean, this is not something you normally would keep on a key ring. It is something that is very specific and very specific to be inserted into that firearm.
Can we get some mens rea on it?
I think that we don't do that with the bump stocks and we don't do that with the other parts,
Bump
the other
stocks are
parts of the
huge,
statute.
though. I
But
mean,
again, I think this is a specific enough thing. It is a unique enough thing that it goes to that if you're in possession, that it carries a 3-year penalty.
somebody's gonna get jammed up that doesn't even know what it is. I'm guarantee it.
Okay. Delegate Conaway.
Thank you, Mr. Chairman. Is there any prohibition on having a set of handcuffs? Because sometimes I see people with handcuffs on their whatever rear view mirrors, so people do keep things on their person that might not be related to what they're doing, or
I think that again, if they're in possession of one of these things, I think it's something that
on
they
the
should have.
keychain, on the keychain.
On a keychain or anywhere else. I don't think that they should have them.
Thank you, Mr. Chairman.
Thank you. There's a motion for the previous question. Is there a second? And a second. We're on the bill, and on the bill is amended. We do the vote on the bill, on the amendment? Did I do that?
Yes.
Yes, okay, so we're on.
Yeah, well.
The speaker bill, no. Delegate, well, we've moved the previous question, but very brief.
If you could tell me, Mr. Chair, this, so are individuals, when they're committing, is this helping them to, I guess, commit the crime by having quickly being able to shoot? I mean, I'm so green in this area.
This makes a handgun that would normally be semi-automatic, and I will look to my friend from. I want to make sure I got the language right because I feel like I'm going to be asked again.
You should
It turns it from a semi-automatic to an automatic, and when I mean automatic, I mean automatic.
Automatic, okay.
Yes. So it means the bullets come out fast and practically at the same time.
And people are using I know you can know this in your line of work.
Them. They're recovering them. He might be showing you a video.
Oh.
All right. We're on the previous question, which is the voting on the bill as amended. Go ahead. Yeah, go ahead.
Oh, I know Kaufman
I'm
has.
falling apart.
So this is just on the auto sears, or are we doing all automatic things?
It's the auto sears. It's
Just auto sears.
Yeah,
Okay.
yeah. The vice chair.
Yes.
Yes. Crutchfield. Yes. Carden.
Yes.
Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. No. Phillips. Yes. Roberson. Yes. Tomlinson. No. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. Sure.
Thank you, Mr. Chair. So the incident that was quoted in the bill hearing was actually in my district. One drug dealer had cased another on a court parking lot, and the case in question, the machine gun was allegedly one of these devices. I just wanted to point out again, 10, 15, 20 years of doing this, we're passing a law that criminalizes ownership, and we're looking right past the bigger problems that's practically how the system deals with these people. There are much more practical things we could do, such as closing the drug dealer loophole, for example. And we know a lot of use of firearms and violent crimes is related directly to drug distribution. I don't think you're going to see a lot of prosecutions of these particular cases. I don't think it's a just thing to do to criminalize ownership. And I think we're not going to be able to capture these people who are either illegally printing or illegally buying these anyway. So I'm going to be a no.
No. Kaufman,
Yes.
yes. Moon, yes. Valentine, no. Conaway, yes. Williams,
What am I doing? Yes.
yes. The chair votes aye. Okay, it's 4:21, and as members of the committee can see, Delegate Kaufman is on his way, and we need him to get on his way so that we can get there for 4:30. We will be voting after the second vote session tonight. This has been this bill voting session for the House Judiciary Committee. There are several bills that are still outstanding.